All right, council, I want to ask for an announcement. What we're going to do on today's hearings. Hunter Huggins, Mr. Green, I'm anticipating you, since you just subbed in, that there's not going to be a contested hearing today.
Yes, Judge, I need just a reset.
Okay. All right, I'll call that back up in a second. Mr. Adams, what about Ms. Villanueva? Are we gonna, that's a docket call today?
Just thought to call your honor.
Okay. Let's see, is Mr. Ashmore back yet? Mr. Biggs, are you here on Cameron Martin?
Yes, sir.
Okay, is that going to be a plea?
Yes, sir.
And that's ready to go? Let's see, is Ms. Chester, there you are. What are we doing on Chelsea Caber today?
We are waiting for confirmation from to
Okay. And then, let's see, is Mr. Hunt here? Is it his back?
we have an agreement on this third item.
Okay, is it gonna be a plea? Okay, and so what I'll do is, as soon as that's ready, let me know, and Judge Thomas is here, and we'll get him in.
Yes, sir.
Mr. Mims, let's see, do we have a hearing, do you have a writ on this, Mr. Baronette, or is that just a writ? Mr. Knoll, what are we doing today? Are we pleading Mr. Creel? That's ready to go. Okay, good. What about Michael Marley?
That I got a phone number to be able to contact wherever they showed that. Said it was just if you're the patient kind of necessary. So I think I'm gonna just innocent stuff. Hospital, I can't remember the name. Get him here that. Reset either towards the end of April. May.
All right, I'll call you back up on that.
Which means
Mr. Wilson, you're pleading, Mr. Gilliam?
Yes, sir.
Mr. Manning, what are we doing on Miss Nix?
We have agreements to withdraw the motion to adjudicate to extend her probation with safety as a condition.
Do you have paperwork already?
Judge, we were waiting on one other document.
We didn't realize that there were two cases. We just have to duplicate the paperwork to the other one. It should be less than 5 minutes, Judge.
Okay. Hunter Huggins, CR 20124. All right, Mr. Huggins is set on a motion to revoke today, and the court has granted the substitution of counsel. Mr. Green now counsel for Mr. Huggins. And Mr. Green, you stated earlier you would like to reset this to the next evidentiary docket.
Yes, sir. Assuming there's not any conflict. Settings already have. Yes, sir.
What about April 28th, the next setting?
Judge, saw my cardiologist, just reported it, that's scheduled for stress testing.
That would set him off until the end of May.
That's probably not any better. Being trial to accuse for it, so. Is there a day before the 28th, Judge?
Not for evidentiary matters, not to conduct a hearing. There's plenty of days to set for docket, discuss, and see if y'all can reach a resolution, but none to.
If we could do that, if we need to, we could set it for, that's the day.
How about, can you come back a couple weeks, April 14th? Or the 26th?
26 would be better.
Yes, as long as he's in jail, yeah.
1:30.
Yes, sir. That day would be remote at the jail.
Okay.
All right, so the court will set this for hearing on 4/26 with the understanding that the state will not be asked to go to a hearing on this motion to revoke on that day.
My business judge, maybe excuse.
Yes, once Mr. Huggins signs, then you can go back to the back of the chart. Mr. Adams, you ready? I'm gonna let him go back before I call her, but she'll be next. Ms. Villanueva, CR 21271. All right, Ms. Villanueva is set for docket call.
Yes, Your Honor. We attempted as best we could to resolve this case with a plea agreement. We've not been able to do that. So at this time, I cannot advise the court whether we're going to plea open or have a slow plea or a full-blown jury trial, but it will not be resolved by plea.
All right, the court will set Ms. Villanueva for jury selection. Beginning April 4th. And just so I can have it on the record, what is the plea offer that she's rejected?
She is indicted for first degree manufacturing, delivery, of controlled substance. The substance of the plea offer was plea of guilty to a second degree substance. Recommendation for 5 years TDC.
So reduction to F2, five years TDC.
Correct.
Ms. Villanueva, do you understand that by rejecting that offer today, the court is very likely not to allow you to accept a plea agreement after today? That I'm going to set you for jury trial? That means if we get to the Friday before trial and you decide, I want to take that 5 years, I'm going to tell you no. I'm going to tell you we're going to trial. Do you understand that?
Just so the court of records clear. This Philip Villanueva, she's not advised me whether she wants to, at a later point, plead guilty as part of an open plea, or to plead guilty as part of a slow plea to a jury, or continue with her plea of not guilty for a jury trial. I explained to her that those were all three possibilities, but that after today, she cannot, the court is advising her that she cannot plead guilty in exchange for plea recommendation from the district attorney's office, as I understand the court's position.
That's correct.
You understand that? So, you understand that after today, Mark is not accepting. Be not later in the district attorney. Do you understand that being the case, you have three different options. That's the first side of the section. Yes. We go through the evidence regarding sentence and jury decide what sentence we understand that. Or we can take the right to get not guilty after the jury trial. You understand that? You understand? Right now, we have all those options available as the free options. Yes. But after today, we will not be able to reach the agreement with the Lansing County District Attorney's Office where they can recommend something for the exchange to the building. Cannot do that. You understand that? And it's the case that I have told you what the Lansing County District Attorney's Office is. Rob Morris offer is. What is that? Was 5? It was 5 years, correct? Once rejected, is that right? In other words, you were not willing to plead guilty in exchange for 5 years keys. Is that right?
Tell you what, Ms. Villanueva, go have a seat. Mr. Adams, if you wouldn't mind, just talk with her a little bit more. And as soon as I see you back up here, I'll work you back in.
I apologize for all this.
Looks like Mr. Hunt's still going over paperwork. Mr. Knoll, are you ready? Brandon Creel, CR 22-8, CR 22-58. All right, Mr. Creel, if you'll raise your right hand and place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, let me put your hand down. Got the windows open. There's a lot of noise. If you can't hear me, just let me know. Just do your best to speak up for me, okay? Thank you, sir. All right, your name is Brandon Ashley Creel. Is that right?
Yes.
And Mr. Creel, are you a United States citizen? Do you read, write, and speak English? Have you ever been diagnosed with any type of mental condition? You have. What have you been diagnosed with? Yeah. Go ahead. Hang on just a second. We're gonna make sure that thing, it's gotta be on green.
Cody.
All right, let's try that again, Mr. Creel. So what I heard bipolar.
Manic depression and anxiety.
Okay. Are you currently on any kind of medications for those?
I just take a sleeping med.
Okay, but you're not on any other kind of mental health medications? Are you under a doctor's care for any of those disorders?
No, sir. I was released from Terrell in beginning of October and then came in here November 1st.
Okay. Do you feel like the fact that you're not on medication right now is in any way preventing you from having
No, sir.
Let me finish. Preventing you from having a rational understanding of what's going on today in court?
No, sir.
Okay. In this case, you're represented by your attorney, Mr. Knoll. Are you pleased with his representation of you?
Yes, sir.
You feel like you've had enough time to discuss both of your cases with him and have all your legal questions answered?
Yes, sir.
Is there anything about the paperwork that you've read and signed that you do not understand?
No, sir.
Mr. Knoll, do you believe Mr. Creel to be competent today?
I do, Your Honor.
And have you explained to him his legal rights?
I have.
Do you believe he understands them?
I believe that he does.
And Mr. Creel, where you have signed these documents, is that your true and correct signature?
Yes, sir.
Did you only sign on once you were confident you knew what you were signing?
Yes, sir.
Mr. Creel, I find that in CR 22-8, you are charged by indictment with a state jail felony offense of unauthorized use of a vehicle, which carries a range of punishment of not less than 6 months or more than 2 years confinement in the Texas Department of Criminal Justice State Jail Division. And in CR 22-5-8, you are charged by information with a Class 8 misdemeanor offense of assault causes bodily injury of a family member, which carries a potential punishment range of not more than 365 days in the county jail and a fine of not more than $4,000. Do you understand the range of punishment?
Yes, sir.
In each case, you do? I see also that there's a plea agreement in both cases. It appears that on the unauthorized use of vehicle case, you're going to plead guilty to that charge. The state's recommending that you be convicted of that offense, but that you be punished under section 1244A, which means that you would be convicted as a felon for unauthorized use of a vehicle, but you would be punished as a misdemeanor offense at 151 days in the county jail, with you receiving credit for all 151 days, being ordered to pay a $1,000 fine, plus reimbursement fees of $820 and court costs of $290. And the state's going to dismiss a resisting arrest, search, or transport charge. And in the misdemeanor case, assault causes bodily injury, family violence, you would plead guilty to that charge. The state recommends the same sentence. Class A misdemeanor, 151 days in the county jail, with you receiving credit for all 151 days for the time that you've already been in jail, plus a $100 fine, $270 court cost, and $15 reimbursement fees. Mr. Creel, is that your understanding of the plea agreement?
Yes, sir.
Yours as well, Mr. Knoll?
It is, Your Honor, and I've explained to him the fact that it is a felony conviction under UUMD, and also that a second charge of assault and violence.
All right, Mr. Creel, understanding the charges, the range of punishment, the plea agreement, this time I'm going to ask you, how do you plead to unauthorized use of a vehicle?
Guilty.
How do you plead to assault causes bodily injury of a family member?
Guilty.
Mr. Creel, are you pleading guilty to both crimes because you are guilty of committing both crimes?
Yes, sir.
Mr. Creel, has anyone threatened, forced, or pressured you to make you feel like you had to plead guilty?
No, sir.
All right, the court will accept the defendant's plea of guilt. Mr. Knoll, any objection to state's evidence?
No, Your Honor.
All right, state's evidence is admitted. The court does take judicial notice of the defendant's judicial confession. Anything further from the state?
Judge, just with no record of the statement, clients will make a notification. The victim is Mr. Creel's mother, who we've been in contact with.
All right, thank you, Mr. Woodward. Anything further from the defense?
No, Your Honor.
All right, the court's reviewed the evidence. I find there is sufficient evidence to support the plea. Court will follow the plea agreement. Court hereby convicts Brandon Ashley Creel of unauthorized use of a vehicle and also assault causes bodily injury of a family member. Court assesses punishment on the state jail felony under section 1244A. Court convicts him of unauthorized use of a vehicle assesses his punishment under section 1244A at 151 days confinement in the county jail. Court gives him credit for 151 days for time previously served. Court orders him to pay a $1,000 fine, $820 reimbursement fees, $290 court cost, and the court dismisses under section 1245 DA 2022-12 a resisting arrest, search, or transport. Court convicts Mr. Creel pursuant to the plea agreement of assault causes bodily injury family member, Class A misdemeanor, assesses his punishment at 151 days in the county jail with credit for time served, orders him to pay a $100 fine, $270 court cost, and $15 reimbursement fees. Mr. Creel, when you are processed out of the jail, within 24 hours, you need to report to the courthouse here and meet with the collections officer, Ms. LaPrade, so you can make arrangements to pay your fines, court costs, and reimbursement fees. Failure to do so is going to result in the court issuing a warrant for your arrest. Do you understand?
Yes, sir.
Mr. Knoll, are you court appointed on these cases?
Man, Judge, honestly, yeah. I'll be here.
All right, Mr. Creel, you hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. I'm going to have you come forward to be fingerprinted with the deputy. Anyone else ready on a plea? Mr. Biggs, are you ready? You got your plea papers? I don't have any up here. Anybody's got plea papers, if you'll go ahead and bring them up, I'll go ahead and line them up. Yeah. Victoria Nix. She went to the restroom? Okay. Raymond Elder.
Judge, due to the sensitivity and the nature of this charge, but names of what the charge is, just for security purposes. Okay. All right, I'll just thought I'd try. Would you mind doing that? I appreciate it very much. Thank you, Judge.
Sure. Elder, how are you doing today, sir?
have no share.
All right, Mr. Elder.
Your Honor, is this dismiss the case? Is this, are you done with me?
Yes. Thank you, Mr. Olin. Caleb Tindall. All right, Mr. Tindall. Sir, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right. And Mr. Tindall, your name is Caleb Rex Tindall, is that right?
Yes, sir.
And Mr. Tindall, you appeared before this court previously. Get back here to it. You appeared before the court on November 13th, 2018. You pled guilty to the state jail felony offense of engaging in organized criminal activity. Court heard the evidence, followed the plea agreement in your case, deferred to finding of guilt, placed you on community supervision for 4 years, ordered you to pay a $1,500 fine. It was during your period of community supervision that the state filed its motion to adjudicate and revoke your community supervision. And in that motion, the state alleged 11 separate counts of ways they believe that you have violated your community supervision. In this case, Mr. Bill Stevens has been appointed to represent you. Are you pleased with Mr. Stevens' representation of you?
Yes, sir.
You feel like you've had enough time to discuss this motion and the allegations?
Yes, sir.
And do you understand everything that you've read and signed today?
Yes, sir.
And Mr. Stevens, does your client waive the formal reading of the state's motion? Yes, sir. Is it his intention to plead true to all counts as alleged? Yes, sir. I see here that upon a plea of true, the state's recommendation is for Mr. Tindall's guilt to be adjudicated, his community supervision to be revoked, and he to receive 9 months confinement in the state jail division of TDC with a balance of his financial obligations, and he would receive 85 days credit towards his sentence for the time he spent in jail. Is that your understanding of the plea agreement, Mr. Tindall?
Yes, sir.
Yours as well, Mr. Stevens? Yes, sir. All right, Mr. Tindall, at this time, I'm going to ask you, how do you plead to counts 1 through 11 as contained in the state's motion to adjudicate and revoke?
Guilty. Guilty.
Are those, well, I need to know, are those counts true or not true?
They're true.
They're true.
Yes, sir.
And Mr. Tindall, are you telling me that those counts are true because it is true, everything that's alleged?
Yes, sir.
Has anyone threatened, forced, or pressured you to make you feel like you had to plead true to anything today?
No, sir.
The court will accept the defendant's plea of true. Mr. Stevens, any objection to the state's evidence? No objection. All right, state's evidence is admitted and the court takes judicial notice of the defendant's judicial confession. And Mr. Tindall, where you sign these documents here today, are you telling me that this is your true and correct signature and you only signed once you were confident you knew what you were signing?
Yes, sir.
All right. And I'll need the state to sign after the conclusion of this. They'll cook stuff off. This was his case. He was the fifth strike in the case. Yeah. I'll give that to you. Let's see. Just get some wet touch. Just tell that man cake. I always catch him on this chair. All right, Mr. Tindall, the court finds that you have violated the terms and conditions of your community supervision. The court will follow the plea agreement in your case. The court hereby adjudicates your guilt, convicts you of engaging in organized criminal activity, a state jail felony. The court revokes your community supervision, assesses your punishment at 9 months confinement in the state jail division of TDC, orders you to pay the balance of your financial obligations, and awards you 85 days credit towards your sentence for the time that you have spent in jail on this cause. You're hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of the sentence. I'm going to have you step forward to be fingerprinted with Deputy Phillips.
Two more cases with you. One, I'm ready to do something with, the other I'm not yet.
Okay.
Fred Rodriguez,
Rodriguez.
we're ready on that. Yes, sir. I've got plea papers on the other guy that I haven't signed yet.
Okay. Good. Good.
So that you know.
All right, so you want me to call Rodriguez?
Yes, sir, please.
Brad Rodriguez, CR 2269. All right, Mr. Rodriguez is set for hearing on his motion to revoke.
Yes, Your Honor, this house and I are still working on the case. I'm getting some medical records from this attorney. I've already submitted some other documentation to him. I believe it's going to work itself out, but we're asking for a court date just because I'm trying to call the documentation. I think this house agrees.
Ms. Heisel, I know you speak on this, Chester. Do you have any objection to Mr. Stevens' request to reset Mr. Rodriguez's motion to revoke? Okay. All right. Do you believe, I'm going to set him to the 28th, April 28th. You available that day?
That's okay, thanks.
You'll be in Mexico. You want to remote in? You want to zoom in from Mexico, from the beach, or what?
Yeah, the 8 o'clock.
Do you know how long it's going to take? I mean, I'd hate to set him out until May.
Well, I'm thinking. He asked the same thing, and I'm hoping to get the documentation. It's medical records, and we just have a little. We hope that.
I can, same thing I did for Mr. Green earlier. I can set you on. When do you leave? When are you going to be available?
I leave on Friday, the 26th.
Friday.
Oh, no, I don't. I'm sorry. I leave on Saturday. the 25th.
The only hearing between now and then, the latest hearing would be April 14th, and that's 2 weeks. We couldn't have a contested hearing that day.
Yeah.
All right.
It's going to work itself out.
All right. Well, we're going to set it for May 26th. And if y'all reach an agreement before then you'll let me know and we'll get you scheduled sooner.
Yes, sir. So, 9 o'clock or 1
1:30, if he's in jail, 1:30. And that will be remote. Oh, no, actually, that'll be here. That's the contested docket date, so it'll be here. It's Miss Nick's back, John. Victoria Nix. All right, it's cause number CR 12 175 and 176. Ms. Nix, I see here that the state wants to withdraw their motion to adjudicate your guilt based on your agreement to extend your period of community supervision for an additional 2 years with you attending the substance abuse felony punishment facility as a condition of your community supervision.
Yes, sir.
So have you been to Safe People before?
No, sir.
Have you been in any type of drug rehab inpatient?
I went to the Genesis Center years and years ago.
So before I sign these, and I'm all about giving people opportunity to go get self-help and get help with their addiction, but I need to know before you go, are you going to go down there with the intentions of changing your life and trying to get off of controlled substances? Because if you're not, let's don't waste the bed. Let's don't waste that opportunity for someone else to go who really wants to go. Do you really want to go? Do you really want to change?
Yes, sir. I really do.
So if I sign off on this, you're going to go down there. You're not going to get kicked out. You're not going to fight. You're not going to violate rules. You're going to go down there. You're going to listen. You're going to learn. You're going to try to bring back things that will help you make decisions, change your mind, change the way you do things, change your discipline, all those things so that you can try to remain drug-free.
Yes, sir.
All right. I'm going to hold you at your word, okay?
Sir.
All right. Court hereby grants the state's motion to withdraw the state's motion to adjudicate in each cause. And the court is going to approve the amendment to the conditions of community supervision. The court notes that Ms. Nix has the advice and counsel of Mr. Manning. So I've signed that. All right. Sometimes people say good luck, you know, it's not really about luck.
Right.
It's not. It's about hard work. It's about
Yes, sir.
accountability. It's about going down and putting down effort, right? So there's always a little luck in life, but you know, it seems like the harder we work, the luckier we are, if you know what I mean.
Yes, sir.
That makes sense?
It does.
If you go down there and do what you're supposed to do, you're only going to improve the chances that you're successful.
Yes, sir.
Okay.
Thank you
All
very
right.
much. But it,
Yes. Was she retained or?
No, Judge, should be on my report. I did this.
Okay, cool. All right. Just want to make sure. Gloria Martinez. Hey, while she's coming up, I got a gift for you. Yeah, I'm talking. I got a gift for you. This was stuck in with one of our pleas a minute ago, and I don't know why. Just a flash from the past. Oh yeah, that's yours to keep. You keep it always the treasure. Deputy McLeish and I talk about that all the time. All right, this is CR 17-297 State versus Gloria Martinez. Ms. Martinez, if you'll raise your right hand, ma'am, I'm going to place you under oath. Ms. Martinez, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth? So help you God.
yes, sir.
All right, may put your hand down. You are Gloria Martinez, is that right?
Yes, sir.
Ms. Martinez, are you a United States citizen?
Yes, sir.
Do you read, write, and speak English?
Yes, sir.
And have you ever been diagnosed with any type of mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Richard Schmidt. Are you pleased with his representation of you?
Yes, sir.
Do you feel like you've had enough time to discuss your case with him and have all your legal questions answered?
Yes, sir.
Is there anything about this paperwork that you've read and signed today that you do not understand?
No, sir.
Mr. Schmidt, do you believe Ms. Martinez to be competent today? And have you explained her legal rights to her?
I have,
And do you believe that she understands them?
yes,
Ms. Martinez, I see that you are charged by indictment with a state jail felony offense of credit card or debit card abuse. That type of offense carries a range of punishment if convicted and sentenced of not less than 6 months or more than 2 years confinement in a state jail division of TDC, and also a fine not to exceed $10,000. Do you understand that full range of punishment?
Yes, sir.
I see that you've reached a plea agreement that you're asking the court to approve, wherein you would plead guilty to the charge, and the state would be recommending that your punishment be 9 months confinement in that state jail facility. In addition, a $1,000 fine plus court costs. Is that your understanding of the plea agreement?
Yes, sir.
In addition, I see that you would have 9 months credit towards your sentence for the time that you have spent in jail on this cause. Is that correct?
Yes, sir.
All right. Understanding the plea agreement and the range of punishment, Ms. Martinez, how do you plead to credit card or debit card abuse?
Guilty.
Are you pleading guilty to that crime because you are guilty of committing that crime?
Yes, sir.
Has anyone threatened, forced, or pressured you to plead guilty today?
No, sir.
All right, court accepts the defendant's plea of guilt. Mr. Schmidt, any objection to state's evidence? State's evidence is admitted and the court does take judicial notice of the defendant's judicial confession. Anything further from the state? From the defense?
Judge, I would note that, for the record, Mr. Martinez has been in continuous custody on this offense since 2017. I understand that the plea agreement is for 9 months. Obviously, that's time served in late terms. The other issue, and I believe that issue, it's my understanding, this is the last piece of business she has in her account. We are entering the expectation that she had enough.
Mr. Schmidt, do you have any concern with the way TDC calculates their sentences versus days versus a month?
Judge, I can tell you that that is a concern, Ms. Martinez, simply because when we were discussing the plea at the time, because it is a state jail sentence, the concern was the transfer from county custody to state jail custody, and what that process looked like on a time served issue. As far as I've been told by a lieutenant at the jail, as soon as the jail receives the PIN pack, that information is sent to the state jail facility and they will issue a release order on time served from there. She claimed that it was roughly a 2-week turnaround period. So obviously my client's anxious to be released because she has been in this for 4 years. That's expedited for this process. So if there is a holdup due to the manner in which that is written, we would rather than waiting to find out down the road. And I'm not really certain how the state jail, like 9 months versus
270.
270. But she does have, she has at least 20 months.
All right, Ms. Martinez. I've already gone through this.
She's already applied. States.
I just haven't pronounced that.
No, you just asked me.
Okay.
Yes.
All right, Ms. Martinez, the court will follow the plea agreement in your case. Court reviews the evidence. I do find sufficient evidence to convict you of this offense. Court follows the plea agreement, convicts you of the state jail felony offense of credit card or debit card abuse, assesses your punishment pursuant to the plea agreement at 9 months confinement in the state jail division of TDC. Court orders you to pay a $1,000 fine, $290 court costs, $70 reimbursement fees, and the court awards you 9 months credit towards your sentence for the time that you have spent in jail on this cause. You're hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of the sentence and have you come forward to be fingerprinted with the deputy. Robert Garrard, CR 2267. All right, Mr. Garrard, it's come to my attention that there has been a request for a personal recognizance bond for Mr. Garrard and allege that he has been in custody greater than the statutory time of 90 days without an indictment. And state, do you have any information for the court that would assist the court in setting. I understand that Mr. Garrard is entitled to the granting of a personal recognizance bond or a bond that he can make. I'm concerned about any conditions that may need to be applied to Mr. Garrard for safety of the community or anything of that nature. Do you have any information for the court on the charge of murder?
Your Honor, oh, sorry, Judge, that was hot. Your Honor, the state received this case from the arresting agency at day 88. Obviously, there was not a grand jury to be held before the 90 days. Mr. Garrard, from my understanding through talking with Mr. Schmidt, I don't believe that he would have the financial resources to participate in something like a GPS monitor. I do believe, based on the facts and circumstances in this case, that there is not an ongoing threat to the community. Without going too much into it, Your Honor, I believe that substances played a large role in this. Conditions of pretrial release that included drug testing and reporting, I think, are applicable to this case. But anything further from that, I don't believe there have been any additional threats or ongoing concern about this being a pattern of behavior on Mr. Garrard's behalf.
Mr. Schmidt, can you assure the court, either as an officer of the court or through Mr. Garrard's testimony, issues about returning to the court should he become indicted?
Judge, I would note for the record that Mr. Garrard was arrested on October 22nd. He was indicted February 24th, 22nd. I think the state was in the states. Continuously been in custody since that date. As far as assurances to the court, I did discuss with Mr. Garrard since the trial, court posed conditions as well as ensuring that he's back and forth to his court dates. State meeting that would not be an issue. I think that since his family lives in Manzanita County.
He does live in the county.
Yes. And ultimately, he is aware that he is. We have not been in yet on this case. Probably take care of that too. But other than that, under those circumstances, and considering the nation problems, join this case. That this is not a ongoing threat to the community to sway to the age concerns.
So, Mr. Schmidt, you said that you'd be willing to conduct the arraignment today rather than April 26th.
Yes, sir.
Okay. All right, go ahead.
Judge, we do know that Mr. Garrard was indicted because of CR 22-067. Mr. Garrard has stated in charge that his name is spelled correctly in the way formal reading to the offense as well as not choosing the paragraph and asking that.
All right, the court will find that Mr. Is it Gerard or Garrard? Gerard. That Mr. Gerard has been indicted in CR 22-67. The court had previously set him for for arraignment hearing on April 26th. The court will find that on this date, he has waived the formal requirements of arraignment, and the court will enter his plea of not guilty into the record. we will set this matter for a pretrial hearing. Would you be available for pretrial hearing? Have you already been given access to discovery, Mr. Schmidt?
Judge, it's my understanding the order of discovery was made available to me today. That's what I'm saying. Any digital, like,
What about May 10th or 12th?
communication notice and traffic.
May 10th should be fine. All right, court will set Mr. Garrard then for pretrial hearing on May 10th. That will be at 9 a.m. if he is on bond. It'll be at 1:30 if he is in jail. Conditions of pretrial release. I see there's already someone on file. All right, so Mr. Schmidt, the court had previously signed conditions of pretrial release for Mr. Garrard on March 16th, a couple of weeks ago. So those will remain applicable, and they're just the standard conditions of pretrial release. So he'll need to sign those before he's released from custody, and the court will grant your request for a personal recognizance bond. Do you have an order? E-file?
Yeah. We're keeping these up.
All right, if I can't find it, I'll let you know. I'll get that signed, but he does need to sign his conditions of pretrial release before he's released. All right, thank you, Mr. Garrard. You can have a seat. Is that all you have, Mr. Schmidt? Mr. Biggs, you ready? Cameron Martin. All right, this is cause number CR 22-60, State versus Cameron Dale Martin. Mr. Martin, if you'll raise your right hand, sir, and place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you may put your hand down. Mr. Martin, are you a United States citizen?
Yes, sir.
Do you read, write, and speak English?
Yes, sir.
And have you ever been diagnosed with any type of mental condition?
No, sir.
Thank you, Mr. Woodwhite. And in this case, you are represented by your attorney, Mr. Matt Bingham, and today, Mr. Biggs is standing in for Mr. Bingham. Are you pleased with the representation you received from Mr. Bingham and Mr. Biggs?
Yes, sir.
And Mr. Biggs, do you believe Mr. Martin to be competent today?
I do, for the record.
Co-counsel. And have you explained all of Mr. Martin's rights as they pertain to him, to this case?
I have your honor, since he was arrested, filing of the information, discovery, review, of plea documents, and all his rights that he's waived.
All right, so Mr. Martin, I see that you've been charged by information with a first-degree felony offense of manufacture or delivery of a controlled substance in penalty group 1, greater than or equal to 4 grams, but less than 200 grams. Do you understand that you have the right to have the grand jury review your case and decide if there's enough evidence to go forward based on probable cause? Do you understand that?
Yes, sir.
Do you understand that the state of Texas, through their attorneys, cannot bring a prosecution against you without an indictment being returned by the grand jury unless you waive that indictment and allow them to do so?
Yes, sir.
In this case, are you asking the court to allow them to proceed with prosecuting you on an information by waiving your right to an indictment?
Yes, sir.
Do you understand that once you waive your right to indictment and the court approves that you can't later go back and require the state to present your case to the grand jury?
Yes, sir.
And you've discussed your waiver of indictment with your attorneys, Mr. Biggs and Mr. Bingham. Is that right?
Yes, sir.
Has anyone threatened, forced, or pressured you or otherwise made you feel like you had to waive your right to an indictment in this case?
No, sir.
All right, the court will find that Mr. Martin has been admonished of his right to waiver or his right to indictment, and that he has waived that right intentionally, knowingly, and voluntarily, and that he has been joined by counsel, Mr. Matt Bingham. All right, Mr. Martin, the range of punishment for a first-degree felony offense, if convicted and sentenced, is not less than 5 years in prison and not more than 99 years or life, and an optional fine not to exceed $10,000. You understand that full range of punishment?
Yes, sir.
And I see here that you want to enter into a plea agreement wherein you will plead guilty to that charge, and the state's recommending that your punishment be assessed at 8 years confinement in prison and a $1,500 fine, plus court costs, reimbursement fees, and you would receive 200 days credit towards that sentence for the time that you've spent in jail on this cause. Is that right?
Yes, sir.
My understanding that Mr. Martin understands he'd go into custody today.
Yes, sir.
Okay. All right, Mr. Martin, understanding the range of punishment, understanding your waiver of right to indictment, understanding the plea agreement. At this time, I'm going to ask you, how do you plead to manufacture or delivery of a controlled substance in penalty group 1 greater than or equal to 4 grams, but less than 200 grams?
Guilty.
Mr. Martin, are you pleading guilty to that crime because you are guilty of committing that crime?
Yes, sir.
Has anyone threatened, forced, or pressured you to plead guilty?
No, sir.
All right, court accepts the defendant's plea of guilt. Mr. Biggs, any objection to state's evidence?
No.
All right, state's evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state? From the defense? All right, court's reviewed the evidence and I do find sufficient evidence to convict Mr. Martin. Court will follow the plea agreement in this case. Court hereby convicts Cameron Dale Martin of manufacture, delivery of controlled substance, penalty group 1, greater than or equal to 4 grams, less than 200 grams. Assesses his punishment at 8 years confinement in the Texas Department of Criminal Justice Institutional Division. Orders him to pay a $1,500 fine, $200 court cost, $15 reimbursement fees, and awards him 200 days credit towards his sentence for the time that he has spent in jail on this cause. Let's see. I see here in the admonishments that it says that there was a 0 fine, but the judge reflects a $1,500 fine. Yes. Take this one. If we'll just amend that and have him initial and acknowledge. Sorry, I couldn't hear you.
We're ready on this bird.
Okay, good. Yes.
Sorry about that.
All right, Mr. Martin, you're hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of the sentence. I'm gonna have you step forward to be fingerprinted with Deputy McLeish, and the Deputy McLeish are to take Mr. Martin in custody. Thank you, Mr. Biggs. Good to see you. All right, so I'm understanding that Ms. Bird is ready.
All right, this court will call cause number CR 12-00349, the state of Texas versus Amy Louise Bird. Is the state ready?
Yes, Your Honor, we're ready.
Is the defense ready?
We're ready, Your
All
Honor.
right. Ms. Bird, do you understand that the state has filed a motion to revoke your community supervision?
Yes, sir. Yes, Your Honor.
And have you and your attorney had enough time to study that motion and decide what to do?
Yes, Your Honor.
Do you understand that because you were placed on community supervision for a second-degree felony, if this court were to find true to any one of the allegations in the motion to revoke, you could be sentenced to up to 2 years in the institutional vision, up to 20 years, and also a possible fine up to $10,000. Do you understand that?
Yes, Your Honor.
All right. I have before me some papers that you signed. Did your attorney go over these papers with you?
Yes, Your Honor.
Did he explain to you what you were signing?
Yes, Your Honor.
And did you understand all of his explanations?
Yes, Your Honor.
You understand that the state, you could force the state to prove these allegations against you. Do you understand?
Yes, Your Honor.
And they would have to do that in a hearing, but you're giving up that right. Is that correct?
Yes, Your Honor.
All right, counselor, do you believe that your client understands what she's doing today?
I do, Your Honor.
All right. Are you going to require that the state read the motion to revoke?
We will wait for you.
All right. Ms. Bird, to the allegations in the motion to revoke, how do you plead, true or not true?
True, Your Honor.
Are you pleading true because they are in fact true?
Yes, Your Honor.
Now, other than the plea agreement, did anyone promise you anything or threaten you to get you to plead true?
No, Your Honor.
All right, I'm going to accept your plea of true. All right. And will the state tell me the plea agreement, please?
Yes, Your Honor. The state is recommending 10 years in TDC suspended for a period of 3 years, a balance of financial obligations, and special conditions of probation, including a GPS monitoring system for the length of her probation, or sorry, excuse me, the length of her participation in the Rock Bottom Ranch program, which is a 1-year drug patient, which is also a condition of probation, and representatives from that program are present here in court today, Your Honor.
All right, thank you. Mr. Hunt, is that correct?
That is, Your Honor.
All right. Is there anything else from the state?
No, Your Honor.
Do you have anything, Mr. Hunt?
Nothing, we just asked that you follow the recommendation.
All right. All right, one thing I failed to do, and I'm gonna correct that at this time. Ms. Byrd, I need you to raise your right hand. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Would any of the answers to the questions or any of the testimony you gave today be different now that you're under oath?
No.
All right, thank you. All right, this court is going to, based on the evidence and the paperwork, is going to revoke or adjudicate your community supervision. I am going to follow the agreement, and although you're receiving 10 years, that's going to be probated again, and I hope we can have a lot different outcome. And I wish you the best of luck. Anything else that needs to be put on the record?
No, Your Honor.
All right, she'll need to come up for some prints. All right, thank you very much. That's all in this matter.
All right, that's my only case that be excused.
Yes, you may. Thank you. Be sure I did, kind of look through those to be sure I didn't miss the signature.
I will, yes.
I'll get you.
This just got to be, that was already there.
Mr. Sawyer, are you ready? Tasha Bells. All right, this is cause number CR 21-319, State of Texas versus Tasha Marie Hobson Bells. Ms. Bells, will you raise your right hand, please? Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you may put your hand down. Ms. Bells, are you a United States citizen?
Yes, sir.
Do you read, write, and speak English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Logan Sawyer. Are you pleased with his representation of you?
Yes, sir.
Do you feel like you've had enough time to talk with him about your case and have all your legal questions answered?
Yes, sir.
there anything about the paperwork that you've read and signed today that you do not understand?
No, sir.
And where you signed the paperwork, would you tell me that that's your true and correct signature and you only signed once you were confident you understood what you were signing?
Yes, sir.
Mr. Sawyer, do you believe Ms. Bells to be competent today?
I do.
And have you explained the facts as they've been presented to you, along with her legal rights as they apply to this case?
Yes, sir. I've explained everything to her, including everything else in the discovery packet, as well as her choice of documents.
And you believe that she understands her legal rights?
Yes, I do.
Ms. Bells, you are charged by indictment with a state jail felony offense of abandoning or endangering a child with criminal negligence. A state jail felony.
Yes, sir.
State jail felony carries a range of punishment if convicted and sentenced to a minimum 6 months in state jail prison to a maximum 2 years and a fine of not more than $10,000. Do you understand?
Yes, sir.
I see here that you want to enter into a plea agreement with the state of Texas where you would plead guilty to that charge, and the state would be recommending that the court defer a finding of guilt, which means that the court consider the evidence today, not convict you, but place you on community supervision for 2 years with a $1,000 fine plus court costs and reimbursement fees. Is that your understanding of the plea agreement?
Yes, sir.
Yours as well, Mr. Sawyer?
It is, Your Honor.
All right, Ms. Bells, understanding the range of punishment, understanding the plea agreement. This time I'm going to ask you, how do you plead to abandoning or endangering a child with criminal negligence?
Guilty.
You're pleading guilty to that crime because you are guilty of committing that crime?
Yes, sir.
Has anyone threatened, forced, or pressured you to make you feel like you had to plead guilty?
No, sir.
All right, the court will accept the defendant's plea of guilt. Any objection to the state's evidence?
No, Your Honor.
State's evidence is admitted and the court does take judicial notice of the defendant's judicial confession. Is there anything further from the state?
No, Your Honor.
From nothing from the defense? Ms. Heisel, so the only thing I have supporting the plea is the indictment. Was that intentional?
No, Your Honor. I'll specify the situation.
You may, yes, sir, you may. And is there still an ongoing CPS case?
No, sir.
for kids? Do you have your children been returned?
Have a what?
Have your children, were your children removed from your care?
Yes, sir.
Okay, did you relinquish your parental rights or
No, sir.
did you go through a plan of services and get your kids back?
No, it was actually, the CPS had closed our case. We were going through you and I missed my last court date. And I never heard anything back, but I know that he's trying to fight me to have my rights taken from me.
So where are your kids now?
Here with him,
With him?
Yes.
Who's him?
Chad Holbert.
All right, court has reviewed the evidence. Court finds that there is sufficient evidence to convict Ms. Bells. Court will follow the plea agreement. Court hereby defers a finding of guilt on the charge of abandoning or endangering a child with criminal negligence, places Miss Bells on 2 years community supervision, orders her to pay a fine of $1,000, $290 court costs, and $570 reimbursement fees. Ms. Bells, you're hereby remanded to the custody of the Van Zandt County Community Supervision and Corrections Department so they can carry out the terms and conditions of the sentence. And have you step forward to be fingerprinted with Deputy McLeish. Is that all you have, Mr. Sawyer? Thanks, sir. Good to see you. Mr. Wilson, are you ready? Billy Jack Gilliam, the third. All right, Mr. Gilliam, if you'll raise your right hand. So do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God.
I do.
All right, you may put your hand down. You are Billy Jack Gilliam III, is that correct?
Yes, sir.
And Mr. Gilliam, you appeared before this court on July 27th of last year, 2021. You pled guilty to the third-degree felony offense of assault of a family or household member by impeding breath or circulation. The court heard the evidence, followed the plea agreement in your case, and the court deferred the finding of guilt in your case and placed you on community supervision for a period of 10 years. And it was during your period of community supervision that the state filed its motion to adjudicate and revoke I'm sorry, that's incorrect. It appears that you appeared before the court and the court heard the evidence. The court assessed your punishment at 10 years confinement in the Texas Department of Criminal Justice Institutional Division. The court suspended that 10-year sentence and placed you on community supervision for 3 years. And it was during that period of time that the state filed its motion to revoke your community supervision. And they alleged in 9 separate counts ways that they believe that you violated your community supervision. Have you had enough time to review this motion with your attorney, Mr. Wilson?
I have.
And you feel like you've had enough time to discuss the case with him and get answers to all your legal questions?
Yes, sir.
Everything that you signed here today, you understand what you signed?
Sir.
Do you have any questions about any of the paperwork?
No.
And I see that your plea agreement is that you would plead true to all counts, and the state recommends that your community supervision be revoked and your punishment be assessed at 6 years confinement in TDC, with you paying the balance of your financial obligations, which is a $448 court cost, and you would receive 298 days credit towards your sentence for the time that you spent in jail on this case. Is that your understanding of the plea agreement?
Yes, sir.
Yours as well, Mr. Wilson?
Yes, sir.
And do you believe Mr. Gilliam to be competent today?
Yes, sir.
And you explained to him all his legal rights?
Yes, sir.
All right, Mr. Gilliam, and does your client waive the formal reading of the state's motion to revoke?
Yes, Your Honor.
All right, Mr. Gilliam, then I'm going to ask you at this time, how do you plead to counts 1 through 9 as contained in the state's motion? Would you tell me those counts are true or not true?
True.
And are you telling me that all those counts are true because all of the allegations are true?
Yes, sir.
Has anyone threatened, forced, or pressured you to plead true to any of these counts?
No, sir.
All right, the court will accept the defendant's pleas of true. Mr. Wilson, any objection to the state's evidence?
No objection, Your Honor.
All right, state's evidence is admitted and the court does take judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor.
From the defense?
Your Honor.
All right, court finds that based on the defendant's plea of true, that he has violated the terms and conditions of his community supervision. The court will follow the plea agreement in this case. The court revokes his community supervision, assesses punishment, at 6 years confinement in the Texas Department of Criminal Justice, orders him to pay the balance of his financial obligations, and awards him 298 days credit towards his sentence for the time that he has spent in jail on this cause. I've got a question on the paperwork here. It says that the original punishment assessed was 5 years deferred, but the motion says 10 pro 3.
It was, originally it was 5 deferred, then it was 10 pro 3, and then we're revoking that. and giving him
Okay,
6
so the original punishment assessed is 5 years deferred.
It was originally 5 deferred, and then he was revoked and adjudicated. Now we're revoking and.
Okay. All right, Mr. Gilliam, you're hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out terms and conditions of the sentence. I'm going to have you come forward to be fingerprinted.
That's all I have.
Yes, thank you, Mr. Wilson. Oscar Robles, CR 16557. All right, Mr. Robles, if you'll raise your right hand, sir. Mr. Robles, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, Your Honor.
All right, you may put your hand down. Your name is Oscar Francisco Robles, is that right?
Yes, Your Honor.
Mr. Robles, are you a United States citizen?
Yes, Your Honor.
Do you read, write, and speak English?
Yes.
Have you ever been diagnosed with any type of mental condition?
No, Your Honor.
In this case, you're represented by your attorney, Mr. Nolan White. Are you pleased with his representation of you?
Yes, Your Honor.
Like you've had enough time to discuss your case with him and have all your legal questions answered?
Yes, Your Honor.
Is there anything about this paperwork that you've read and reviewed and signed with Mr. White that you do not understand?
No, I understand it all.
Mr. White, do you believe Mr. Robles to be competent today?
Your Honor, I believe Mr. Robles is competent, believe he understands the proceedings that are pending against him here today in the court village. From the court, we have a waiver of rights. I believe that he waived the rights. No, voluntary.
All right, Mr. Robles, I see here that you are charged by indictment with a second-degree felony offense of possession of a controlled substance in penalty group 1, greater than or equal to 4 grams, less than 200 grams. The range of punishment for that crime is not less than 2 years or more than 20 years confinement in TDC and a fine not to exceed $10,000. Do you understand the full range of punishment?
Yes, Your Honor.
And the plea agreement in your case is that upon your plea of guilty, the state's recommending to the court that your punishment be 3 years confinement in TDC with a $1,500 fine plus court costs, reimbursement fees, and you receiving 242 days credit towards your sentence for the time that you've been in jail on this cause. Is that your understanding?
Yes, Your Honor.
And that's the plea agreement you want the court to approve today?
Guilty.
Okay, well, I'm just saying, we haven't got to that point yet, but that's
Okay,
what you're
sorry.
wanting the court to approve.
Yes, Your Honor.
All right. So at this time, Mr. Robles, I will ask you now, how do you plead to possession of a controlled substance in penalty group 1, greater than or equal to 4 grams, less than 200 grams?
Guilty, Your Honor.
Are you pleading guilty to that crime because you are guilty of committing that crime?
Yes, Your Honor.
Does anyone threaten, force, or pressure you to plead guilty?
No, Your Honor.
Court accepts the defendant's plea of guilt. Mr. White, any objection to the state's evidence?
No objection.
State's evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state? And I just noticed here that the indictment alleges an enhancement and is charged in the first degree. Is that right?
That's correct, Your Honor. The state is proceeding with just dropping the enhancement part of that, which would be the allegation and proceeding only on the possession of controlled substance. That's correct.
All right. So what I would ask from the state, just because we've had this issue with TDC, is a question. They go through and they read the stipulation. They're going to see first degree, and then they're going to see second degree, and then they're going to contact me. They're going to ask me to clarify that. So what I'd like to do at this time is state, if you would just mark that out and put on the record that you're abandoning the enhancement paragraph and just proceed with the second degree.
Would you like me to write abandon, Judge, or just sign it?
Yeah, I'll write abandon. And I think that will stave off any confusion when they start reviewing. Thank you, sir. All right, court has reviewed the evidence. I do find sufficient evidence to convict Mr. Robles. Court will follow the plea agreement in this case. Court convicts Oscar Francisco Robles of possession of a controlled substance in penalty group 1 greater than or equal to 4 grams, less than 200 grams, second degree felony. The court assesses his punishment in accordance with the plea agreement at 3 years confinement in the Texas Department of Criminal Justice, orders him to pay a $1,500 fine, $290 court cost, and $85 reimbursement. Court awards him 242 days credit towards his sentence for the time that he has spent in jail on this cause. Mr. Robles, you're hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of the sentence and have you come forward to be fingerprinted with deputy completion.
Oh, that's all I have.
Yes, sir. Thank you, Mr. White. Yes. Let me do one more and I'll get her. Ms. Chester, are you ready on is Ms. Caver here? I see you hear this. Okay, Ms. Caver, if you'll come up, please. All right, so this is cause number CR 16633, State versus Chelsea Caver. Court finds that the state has filed a motion to withdraw its motion to revoke and terminate. And it appears that the agreement is that Ms. Caver is going to request amendment to your conditions of community supervision. It's going to require you to submit to the use of a GPS monitoring device. It's also going to require that you attend and graduate from the Rock Bottom Ranch program in Palestine. And you're going to have an extended period of community supervision for an additional 2 years. Your original expiration date was April 17th of 2022. And now your new date, if approved, would be April 16th, 2024. So Ms. Caver, if you'll just raise your right hand. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir.
All right. All right. So Ms. Caver, you understand what I've read to be the amendments to your conditions of community supervision?
Yes, sir.
And you've gone over those with your attorney, Ms. Casey Chester. Is that right?
Yes, sir.
And you understand that it's going to extend you for an additional 2 years.
Yes, sir.
And during that 2 years, you're going to incur additional financial obligations.
Yes, sir.
And do you believe that by amending your conditions of community supervision, it's going to improve the likelihood that you successfully complete your term?
Yes, sir.
Has anyone threatened, forced, or pressured you to make you feel like you had to agree to any of the amendments to your community supervision?
No, sir.
Ms. Caver, do you believe that, I'm sorry, Ms. Chester, do you believe that Ms. Caver is competent to enter into this agreement today?
Yes, Your Honor, I do.
And you've gone over all of these amendments with her, and you believe that she understands what she's doing?
Yes, we've gone over them and she's told me that she understands the conditions.
Okay. All right. The court will find that Ms. Caver has been admonished regarding her amendments to her conditions of community supervision, and that she is making this decision of her own free will. The court is going to grant the motion to withdraw, the motion to revoke and terminate, and approve the amendments to her community supervision. Yes, ma'am. Do you have a payment sheet?
I will be one to their.
Okay. All right. Thank you. Ms. Villanueva? All right, this is CR 21271, State versus Teresa Villanueva. Record will reflect that previously we've had discussions about rejection of the offer. There was some confusion on Ms. Villanueva's part. Court asked Mr. Adams to discuss that with Ms. Villanueva. Is she ready to make an announcement to the court?
Yes, Your Honor, she is. After recess, during our recess, Ms. Villanueva and I visited again about our options. Fairly confident that she understands what each one involves, and pros and cons of each option. Ms. Villanueva advised me during recess that she wishes to accept the state's offer. Which would be for a recommendation of 5 years TBC. So whether is that still the case? So we are going to accept the state's plea offer. Don't have a waiver of jury trial or have to provide the court.
I bet the state would be happy to oblige, correct?
Yeah.
All right, so we'll do a waiver of jury trial and set for a plea.
Yes, sir.
All right, Ms. Villanueva, if you'll raise your right hand. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so be God?
Yes, sir.
All right, you put your hand down. All right, so Ms. Villanueva, today's setting is for docket call. And the purpose of docket call for this court is for the court to determine what you want to happen on your case. And at this juncture, you have decisions to make. And those decisions are you enter into a plea agreement, like Mr. Adams has outlined, or you request the court to try your case one of two ways. Either the court hears all the evidence in the case, decides whether you're guilty or not guilty, and the court could assess your punishment, or you can ask the court to give you a jury trial, and a jury would be picked to hear all of the evidence in the case, and then the jury would decide if you're guilty or not guilty. And then if you were guilty, then you could elect for the court to assess punishment or for that same jury to assess punishment. Do you understand all of those options? You do? Yeah, just make sure you're talking into that microphone.
Sir. Yes, sir.
Okay, good. All right. And so Mr. Adams has explained to me that y'all had those discussions, that you understand that, and that today you're wanting to enter into a plea agreement, or you're wanting to accept it today. Is that correct?
Yes, sir.
And you understand that you don't have to accept the offer.
Yes, sir.
And you understand that that's your right to make that decision. Has anyone threatened, forced, or pressured you? Mr. Adams didn't come back there and tell you you had to take the 5 years. Is that right?
No, sir.
Has anyone else?
No, sir.
And so your decision to accept the 5 years is based on what you want to do.
Yes, sir.
All right. And so you also have the right to have your case, as I've mentioned, tried before a jury of your peers. And that's a right that you enjoy, that we all enjoy, and it can't be taken away from you. However, you can waive that right, meaning you can give that right away. You understand that if you waive the right to a jury trial, that right may not be given back to you at a later date.
Yes, sir.
And if you waive your right to a jury trial, you're waiving the right to confront all of the state's witnesses and their evidence in front of that jury. You understand that?
Yes, sir.
So if you execute a waiver of jury trial today and you say, Judge, I understand that I have a right to a jury trial and I'm going to waive that right, and I'm doing this because this is what I want to do, and I understand what I'm doing. If you change your mind later before you enter the plea and say, Judge, I don't want to do that anymore, I want a jury trial, there's very limited circumstances in which you could have that right restored to you. Meaning, once you give it away, it's not likely to be given back to you. Do you understand that?
Yes, sir.
Okay. And have you discussed that with Mr. Adams today, waiving your right to a jury trial?
Yes, sir.
And so in a moment, he's going to bring a document to you, and he's going to go over that with you. And once you sign that, then when you come back up here, if I accept that, then that means we're going to set your case to enter into a plea agreement at a later date.
Yes, sir.
You understand that?
Yes, sir.
Okay. Do you have that document? Yeah, go ahead and do it right now. We'll take care of it all at this time. You may. Do you have a date in mind? Bet.
Not really far.
Look over your calendar real quick. All right, Ms. Villanueva, so you have signed this document called waiver of jury trial. Did you read over that and discuss it with Mr. Adams? All right. Court will find that Teresa Ann Villanueva has been admonished of her right to a jury trial, that she has waived that right intentionally, knowingly, and voluntarily. The court approves the waiver of jury trial, finds that it is joined by attorney for the defendant, and the state's also waiving their right to a jury trial in this matter. And we'll set this for a plea.
Your Honor, Thursday afternoon, May 7th.
May 7th?
April 7th, I'm sorry.
Yeah, we're going to be in jury trial that week. So I've got the upcoming dates that I have for criminal are April 14th, 26th.
The 14th, I'm here already.
Let's do that then. All right, so we'll set Ms. Villanueva to enter a plea on April 14th, and that'll be 1:30. April 14th. All right, you want to give her that yellow, have her sign that yellow, the notice, and give her the yellow copy, and it should be good to go.
Yes.
Mr. Sanders, are we going to be having a hearing on Mr. Ellis?
Yes,
Motion to adopt. Do you know about how long that's going to take?
I don't think it'll take, maybe a few minutes. It's really just an argument, it's not.
Okay. Mr. White, are you still waiting on plea papers? Yeah, you got everything. Let's rock and roll.
All we're doing is continuing, extending probation.
Tasha Messick. All right, this is cause number CR 2185, State versus Tasha K. Messick. Ms. Messick, if you'll raise your right hand. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you may put your hand down. All right, Ms. Messick, I see here that you've entered into an agreement with the state. The state's going to withdraw their motion to revoke that they previously filed. And your part of the deal looks like you are going to submit to an additional 1-year period of community supervision. Originally, your expiration date was May 25th of 2023. Now it would be May 24th, 2024. And that you're going to serve an additional 44 days in jail as a condition of your community supervision. And you would receive credit for time that you've already served between the dates of December 4th, 2020 and February 17th, 2022 through March 31st today, 2022. Is that your understanding of the plea agreement? She thinks she's going to do more jail time, I already tell you.
Okay, so I don't have to do more. Okay. Yes, sir.
No, ma'am, you're going to receive credit for the time that you've already served on those dates that I said. All right, Ms. Messick, has anyone threatened, forced, or pressured you to make you feel like you had to extend your community supervision?
No, sir. No, sir.
Okay. And if I extend this community supervision, am I going to get any more motions to revoke your community supervision?
No, sir.
Just the last one?
Yes, sir.
If we get another one, what do you think is going to happen?
Probably 2 years. Probably the max.
Say again?
The max sentence.
All right, the court will approve the amendment to the community supervision, will grant the state's motion to revoke and extend the community supervision, finds that Ms. Messick has intentionally, knowingly, and voluntarily agreed to the amendment of her community supervision. All right, last chance. Thank you, Mr. White. Thank you, Mr. Adams. Appreciate it. All right, Mr. Mims, you ready? Shane Baronette, CR 2261. Do you want to have your client sit with you at council table? Do you want to have your client sit with you at council table, or do you want him to stand up? Okay. All right, so let's take up the arraignment first. I believe we're set for arraignment on CR 2261. Have you had a chance to go over the indictment with your client?
Yes, I thought we filed a waiver.
You may. When did you file it? Do you know?
I filed a waiver.
No, let's just go ahead and arraign him if you. All right, go ahead. Is his name spelled correctly in the indictment?
Yes.
Does he understand what he's charged with?
Yes.
And how do you wish to enter a plea? All right, and you waive the formal reading of the indictment?
We do.
All right. Court finds that Mr. Baronette has waived the formal reading of the indictment, enters his plea of not guilty. The court will enter that into the record. And the court will set this matter for pretrial. Do you have your calendar with you, Mr. Mims? Are you available on either May 10th or 12th for pretrial? 12th?
Yes.
All right, court will set Mr. Baronette for pretrial hearing on May 12th at 1:30 if you are in jail, 9 a.m. if you make bail, okay? So if you're out, your court hearings will be at 9 a.m. If you're in jail, then we'll come to you, or you'll be brought over in the afternoon, okay? All right, and so you filed a motion to reduce bond, is that correct?
And also, somewhere there's an application for a PR bond. I filed it as a writ. I'm not sure it's on the docket today.
I'm sorry, Aaron, can you turn that microphone up? Because I'm having a hard time hearing. I don't know. Well, I don't know if it's that. I mean, we're getting nothing on that. Will you do me a favor? Will you just tap it? Just tap it. It's kind of been going haywire on us lately. All right, do you want to call your client for the purposes of the bail reduction?
I'll have two other witnesses. I will get. I'll have. I've got two other witnesses.
Okay.
Your Honor, we're proceeding on 17-151.
Y'all tell me.
He was timely indicted, Judge, so I'm not sure there is I'm not sure he's entitled to anything under 17-151.
I see.
There's another motion
I see that there was a defendant's motion to reduce bond that was filed March 14th under this cause number.
If I may, there's two cases. One is the aggravated assault with deadly weapon. That's $150,000. That's indicted. There's also felon in possession of firearm. It's not indicted, as far as I know. That's happening. That's the one we're seeking the PR bond on, since he wasn't timely indicted. On the $150,000, that's what we're asking.
The felon in possession of firearm judge has already been declined. That notice has been sent to the jail already. In that case, the felon in possession has been declined. So the notice is already sent to the jail, so the bond should come off.
Do you know, just for the record, when that was sent? So we'll have it.
It looks like February the 18th.
February 18th. Okay, so then that just leaves us the motion to reduce bail in this indicted cause. Okay.
Judge, I just talked to witnesses on it. There'd be less than 10 minutes.
All right, go ahead. Call your first witness.
First witness,
Ma'am, come on up. Just come on up here. You can, sure. Ma'am, I'm sorry, I didn't hear.
Or which can you pronounce it? Spells H-Y-M-E-L.
H-Y-M-E-L. All right, ma'am, if you'll raise your right hand. Ma'am, you swear that the testimony given in court today will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
All right, please have a seat.
Thank you.
The chair will move so you can make yourself comfortable. Then just speak up loudly, clearly into the microphone. We have to open the windows. It's a little bit loud. Allow Mr. Mims and Ms. Curry to fully ask your questions before you try to answer my court order to your left. Let's take down everything that we say. It's very difficult for her whenever y'all start talking over one another. Right? So if you anticipate what the answer is, don't start talking. Let him finish, and he's going to do the same thing. Okay? Mr. Mims.
Thank you. And we know you're married at the time, but where do you live at the time?
Prairieville, Louisiana.
And she's got to take all this down, so speak up. I hear you.
Prairieville, Louisiana, Prairieville, Louisiana.
And what do you do for a living first?
I'm retired.
Okay, retired from what?
I am worked for Uniroyal Chemical Administrative Assistant for years and now retired from there.
You have a son?
I have a son,
What is your son's name?
Shane
Name?
Baronette,
And
Baronett. Yes, sir.
And would you talk to him?
Yes, sir.
Word? Could you tell the judge what he's wearing? We're taking this down.
Orange jumpsuit.
Judge, let the record reflect. It's not- Looks like in this case.
All right, record will reflect that this witness has identified the defendant in this case, Shane David Baronette.
Okay, now, the judge has to make, we're asking the judge to lower a bond from $150,000 to a lower amount. Is that correct?
That's correct.
What efforts have you personally made to secure this $150,000 bond so that he can obtain this agreed on pending control?
Well, his wife and I are looking at a bail bond information. I've called quite a few times to see what the specifics are in reference, to what would be needed.
And typically, that's going to be $15,000 more or less to $150,000.
That 10%, yes.
Okay, do you have that sort of money available, any kind of resources to make that bond?
No, sir.
Do you know if he needs?
Not that I know, sir.
The other thing, the judge has to make sure that if he does make bond, that he's not a flight risk.
That's,
That is,
yes, sir.
tell the judge what you think that is.
Well, a flight risk is pretty serious. And I feel like I have had to really soul search in my mind to make sure that, I'm a mother. So, others have a tendency to say, yes, help my son, but I have soul searched and I feel like through our conversations that he's not a flight risk, that we can definitely handle.
Passport.
No,
The other thing is, he's charged with serious criminal offense.
Yes.
Assault, deadly weapon.
yes,
Judge has to make sure that, or be comfortable that he's not, if he gets out, he's not a danger to the community or anybody in. What can you do to assure the judge that he's not a danger?
Oh, we have set up his wife and because she'll be the main person with him on a daily basis, but I will assist if needed, definitely drive over here and set up a protocol in reference to, I'm not going to base anything on luck. He's going to have rehab and, rules set in place because that's the only way you can do something. I'm not going to just say, come home and we'll sit there and wait for something, just by the seat of our pants, hope that everything goes well. No, that's not what we're doing. But we're both strict, Courtney and myself. So we have the background to be able to handle such a situation.
So you promise the court that you'll do everything in your power to make sure that when this is set, I believe it's February the 12th coming up, that you'll make sure he's here if he makes bond.
Most definitely. Yes.
Would you have the money to make a $25,000 bond?
I think I could handle 25,000. That's a lot to handle.
Ms. Curry, any questions?
Yes, Your Honor, thank you. I'm sorry, ma'am, I missed your name. I like Mr. Mims. I'm just as hard of hearing as he is. So, and I missed your name. What is it?
Maryland and last name Hymel. We can say Heimel. We pronounce it email, but Heimel's just great.
Okay. So, Ms. Emil, you live in Louisiana, is that right?
Yes, ma'am.
Okay, so at the time that your son was arrested, where did he live?
Van Zant County.
Okay, and are you going back to Louisiana to live?
I am.
If your son, Mr. Baronette, is released on a bond, where is he going to live?
He is going to live with his wife at his current home.
In Van Zant County?
In Van Zant County, yes, ma'am.
So you'll be a couple hundred miles away?
That's correct, but Courtney can call me at any moment and I'm available.
And how long is the drive from Louisiana?
It would be 6 hours.
6 hours. How many times has your son been to prison?
Never.
How many felonies has he been convicted of?
None that I know of in reference to, I'm not sure about a felony.
Okay,
One?
so before your son was arrested, when was the last time you saw him?
Oh, I was there that full week when everything was occurring at his home.
So you were staying at his home when this offense occurred?
Yes.
Okay, so
No, I left 2 days before this happened.
Okay, so you left 2 days before.
Yes.
And where had your son been while you were there?
At home.
Did your son have mental problems?
No.
Has he ever been in a mental health facility?
Yes. And that was, I picked him up from that mental health facility. And that was 6 days before this occurrence.
So 6 days before this occurred, you picked him up from the mental health facility, but he doesn't have mental health problems.
That's correct.
Was he unlawfully detained in that facility?
Not unlawfully. How?
It's legal to put someone who doesn't have mental health problems in.
Okay, well, this is what I spoke with the social worker and I asked her and she said no, that he would be not mentally ill, released with a mental illness, that it was delusional.
That it was delusional?
Yes, ma'am.
But delusional is not a mental illness?
Well, at that time, very. but not on a normal basis. Okay, I'll explain. It's so hard for me to understand everything that you say, but Shane has had some back issues and he was on medication. He tried on his own to take himself off of the painkillers that he was prescribed by his doctor because he felt like it was ruining his life. And when that happened, that's when everything went wrong. And before there, we have had no issues whatsoever with Shane. He was a man with his own business. He worked 12 to 14 hours a day. He learned how to handle his customers. We had no issues like this. And if I had a son that was always in trouble, always getting arrested and all that, I wouldn't be standing up here, but that is not what happened to us. It was a very, I don't know quite the word, unique situation that came into play.
So he became delusional after he got off of the pain medication.
Correct. It gets like it changed the chemistry in his brain.
And that caused him to be in a mental health facility.
That did, yes, ma'am.
One time or more than one time?
One time.
And you picked him up from that mental health facility 6 days before November 29th, is that correct?
That's correct.
You were there for about 4 days and you left and went back to Louisiana.
I stayed a full week. My days exactly. I left 2 days before this incident occurred.
So you were in Louisiana when this incident occurred?
Yes.
So you couldn't stop it from occurring?
That's correct.
And what is this incident, by the way?
He
went
crazy and he pulled a trigger on a gun. Yes, he shot me.
And if you're 6 hours away, you can't stop that from happening.
But his wife is there. He's not alone.
Well, his wife was there the day this happened, right?
No,
Oh, she wasn't.
no,
She fixed to testify next.
she will.
Do you know who gave him the gun 6 days after he got out of the mental health hospital that he shot the man with?
Yes,
Who?
his wife, but she was,
Gave him a gun.
yes, but he was forcing her.
Nevertheless, she gave him a gun 6 days after he got out of the mental health hospital, and now you think it's appropriate for her to watch over him.
Yes.
Okay, I'll pass it.
Mr. Mims? No more?
No problem.
All right, thank you, ma'am. You may step down.
Thank you.
What's your step, please?
Thank you.
I'm sorry, what was the name?
Courtney Baronette, B-A-R-O-N-E.
Ms. Baronette? Baronette, if you'll raise your right hand. Ma'am, do you swear that the testimony you give to the court today is the truth, the whole truth, and nothing but the truth, so help you God? Set seat. You move that chair around, make yourself comfortable. Just speak up as loud as you can into that microphone so we can all hear you, okay?
Yes, sir.
Go ahead, Mr. Mims.
Thank you. All right, we know you're Courtney Baronette. Where do you reside, Ms. Baronette?
Ben Wheeler in Van Zandt County.
Is that Van Zandt County?
Yes, it is.
And specifically, do you and your husband own property in this county?
Yes, sir.
Tell the judge what property you own.
Before we go further, if this witness testifies and is subject to cross-examination, she's going to have to be warned and provided a lawyer, judge, because I'm going to ask her about a felony, about 2 felony offenses that I know that she committed in relation to this.
Counsel, we all approach.
Yeah.
you, Ms. Baronette. You may say. Do you have any more evidence, Mr.
I did
Mims?
not.
All right. Does the state have any evidence it wants to bring on this matter?
Your Honor, we just have two exhibits we'd like to offer. The first one, Judge, is the affidavit of probable cause in this case. The second one we would offer under seal, which is a copy of Mr. Baronette's criminal history that does reveal a conviction out of Louisiana where he was sentenced to 3 years hard labor, probated for 2. Yes, 3 years hard labor, suspended, and probated for 2 for possession of cocaine.
I don't have objection to that one.
No objection to number 1. No objection to 1 or 2.
And 2 is under seal, Judge, because it is a criminal history.
All right. There being no objection, the court will admit State's Exhibit 1 for the purpose of this hearing. And the court will also admit State's Exhibit 2 under seal. We'll direct that this be sealed in the clerk's file. Any further evidence, Ms. Curry?
No, Your Honor.
Would you like argument, Mr. Mims? All right. Would you like argument?
Yes.
Go ahead.
Judge, we've asked the court to reduce this bond to $25,000. Ms. Hyman, Mr. Back, Don Blackness, doesn't have a passport to leave the country. The reference to the big and middle institution, she's talking about it, when it's a drug. We asked if he's not going to be a major committee, properly supervised by the pretrial services department here in Vincent County. Reasonable lodge conditions could be consuming alcohol, consuming not possessing firearms, released to the custody of his wife, who lives in, got their Edom. They've got property that they've had years now. There was a, I think it's there wasn't any divorce that's in this court. I believe it might have been a hearing. Looks like they have reconciled and gone back together. Try to get through this position. So she is invested in this case. She did this business. So with respect to a set of circumstances, reasonably sure that he's going to trial, surety bond, the fact that he's got property here. I guess it's true of that, but it would be something that would be more of a risk of him losing that property than it would be him leave for the final consideration. So we submit the $50,000 surety bond, legally surety to the board to protect the community and guarantee. We ask the court to consider $25,000 for something that $50,000. The title of that, section 13, is presumed to be innocent. Maybe that he could be convicted at trial. Later on, we'll know that later on. But presently, he's entitled to the reasonable bail to get forward. I think that somewhere in that range of $25,000 to $50,000 would redeem his rights under the Constitution, protect the public, guarantees.
Is there any issue of competency at this point, Mr. Mims, that you're aware of?
I will represent the court while I didn't bring. We had him evaluated recently while he was in jail by a clerk officer. His local family after he went to jail for a while, he did not have any competency issues or was actually does not have delusional issues that this is how we're talking about. This was about asked her for the report, but it's not ready.
Okay.
Furnish it to the court later on.
Okay, thank you, Mr. Mims. Ms. Curry?
Thank you, Judge. Your Honor, it's our information. Judge, we think the bond that is set by the court originally is an appropriate bond in this case. The testimony is that Mr. Baronette's mother lives 6 hours away. Obviously, there's nothing she could do to prevent this offense from happening or to prevent a further offense from happening. While we have no information that indicates he is a flight risk other than the range of punishment that he faces and his criminal history, the concern here, Judge, is the safety of the community. If you look at the addresses on State's Exhibit 1, if he goes home, he's 3 doors down from the man who shot, living with a woman who handed him a gun in the middle, while he's in the middle of a delusional episode. We feel like, Judge, that the bond that is set needs to remain where it is in order to protect the community from the actions.
Okay. All right, the court will take this under advisement and I'll issue a ruling at the conclusion of my docket today, and I'll send notice to both the state and to you, Mr. Mims. Yes.
Thank you very much.
Thank you, sir. Good to see you. Thank you, Mr. Baronet. You can go back to the back. Mr. Knoll, are you ready on Mr. Ebert? Bobby Lee Ebert. Ms. Ebert, if you'll raise your right hand. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, nothing but the truth? So if you got.
Yes, Your Honor.
All right, you put your hand down. Ms. Ebert. You appeared before the court on January 7th of 2020. You pled guilty to the offense of burglary of a habitation. The court convicted you on that day, sentenced you to 10 years confinement at TDC. The court then suspended that sentence and placed you on community supervision and probation for 5 years, ordered you to pay a $1,500 fine. And it was during your community supervision period that the state filed 2 counts alleging 2 ways that you violated your community supervision. Mr. Kurt Knoll was appointed to represent you. Are you pleased with his representation of you?
Yes, sir.
You feel like you've had enough time to discuss the state's motion with him and have all your legal questions answered?
Yes, Your Honor.
Is there anything about this paperwork that you've read and signed today that you do not understand?
No.
And where you did sign, did you only sign once you were confident that you knew what you were signing? And is that your true and correct signature?
Yes, sir.
Mr. Knoll, do you believe your client to be competent today?
I do, Your Honor.
And have you explained to her legal rights with regards to this motion?
I have, Your Honor, in reference to the state's offer, there was also an alternative offer of safety. Discuss that. She's opted to take the sentence.
And does your client intend to plead true to both counts as alleged?
She does, Your Honor.
And does she waive the formal reading of the state's motion to revoke?
We do, Your Honor.
All right, Ms. Ebert. And I see here that the plea agreement in this case is that you would plead true to counts 1 and 2. The state would recommend that your community supervision be revoked, that you be sentenced to 3 years confinement in TDC, and you be ordered to pay the remaining balance of your court costs, fine, and restitution, and that you would receive 264 days credit towards your sentence for the time that you spent in jail. Is that your understanding of the plea agreement? All right, understanding the plea agreement then, Ms. Ebert, at this time, how do you plead to counts 1 and 2 as contained in the state's motion? Are those counts true or not true? And are you telling me that those counts are true because, in fact, they are true?
Yes, sir.
And has anyone threatened, forced, or pressured you to plead true to either count? All right, the court will accept Ms. Ebert's pleas of true to counts 1 and 2. Any objection to the state's evidence?
No, Your Honor.
State's evidence is admitted. The court takes judicial notice of the defendant's judicial confession. Anything further from state?
No, Your Honor.
From the defense?
No, Your Honor.
All right, based on the court's acceptance of Ms. Ebert's plea of true, the court will find that she has violated the terms and conditions of her community supervision. The court hereby revokes her community supervision, sentences her to 3 years confinement in the Texas Department of Criminal Justice, orders her to pay the balance of her financial obligations, and awards her 264 days credit towards her sentence for the time that she has spent in jail on this cause. Ms. Ebert, you hereby remanded to the custody of the Van Zandt County Sheriff so we can carry out the terms and conditions of the sentence. And have you step forward with Deputy McLeish to be fingerprinted. Good luck to you. All right, Mr. Knoll, are you ready on Mr. Marley? You want to go ahead and announce on that one? Michael Marley, CR 21225. All right, Mr. Marley is set for a status on his medical records. You were advising me earlier, but go ahead, restate for the record, please.
Just, going back a little ways, I filed the motion actually ordering with no fee to be paid. The court was inclined not to sign that and understand that. So then actually, I think Ms. Abraham got a number where I believed, and I think she believed that I could call them, 800 or 888 number, I forget exactly. I called, it was an automated system that was actually set up for really the patient to be able to, I guess, put information in over the phone is the way it sounded like, to get records. So just to back up a little bit so the court knows why I'm hoping the records not influence the case. I think it's 2 days before the incident happened. There was a surgical procedure.
Inguinal hernia. It was a double inguinal hernia.
Hernia procedure done at one of the local hospitals. They prescribed, among other things, when he got out, pain medication. And the incident that's alleged, which is actually a felon in possession of a firearm, occurred both on pain medication and I'll admit, and I think the records were. So there is, to my way of thinking, at least that may be mitigating, and that's why I'm trying to get that particular information. And I know at one point in time, actually, the jail here had the medication, but because it was a narcotic, they never gave it the medication. It's the pain medication. I think there's also medication for possible infections. That's the usual kind of thing you get surgical.
So what's going to be the plan of attack going forward to get those records?
I think the only way now is just to issue a subpoena to the hospital.
So you're gonna request that?
Yes.
Okay. All right, so we'll reset Mr. Marley for another status on medical records. Let's, today being the 31st, are you available either May 10th or 12th?
I'm on the beach, hopefully someplace in Hawaii.
Are you going with Mr. Stevens?
Go to Mexico?
No.
Oh, okay.
Why?
Oh.
The 3rd through the 17th is
In May?
Yes.
Okay. So we need to look at a different time. What about May 24th? Come back with a 10.
Yeah, is that a Thursday, I guess?
That's a Tuesday. I don't have Thursday that. I've got evidentiary dates. Yeah, I tell you what, we could do it on May 26th. It's evidentiary day, so.
That'll be fine, Judge. Cindy's still gonna be incarcerated, so that'll be May.
May 26th at 1:30.
I'll get
If y'all get something worked out before then, you let me know. We'll get it worked out.
Yes, sir.
Mr. Egret. Mr. Mr. Egret, if you'll raise your right hand, sir. Sir, do you swear that the testimony you give to the court today would be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, maybe put your hand down. You are Blake Austin Egret, is that right?
Yes, sir.
And Mr. Egret, you appeared before the court on October 20th, 2020. You pled guilty to possession of a controlled substance in penalty group 2, greater than or equal to 1 gram, less than 4 gram. Court heard the evidence, found that there was enough evidence to convict you of that charge. However, the court followed a plea agreement, deferred a finding of guilt. That means didn't convict you, but the court placed you on 2 years community supervision. And it appears that during that period of community supervision, the state filed a motion to adjudicate, that means to convict you. And they also filed this motion requesting that the court revoke your community supervision. And in this motion, they put in 12 different counts alleging ways that you violated. And the court has appointed Mr. Stevens to represent you. You feel like you've had enough time to discuss this motion with Mr. Stevens?
Yes, sir.
And are you pleased with his representation of you?
Yes, sir.
And Mr. Stevens, does your client waive the formal reading of the state's motion to adjudicate?
Yes, sir.
And does he intend to plead true to all 12 counts?
Yes, sir.
And do you believe him to be competent today?
Yes, sir.
All right, Mr. Egret. Then at this time, I'm going to ask you, how do you plead to counts 1 through 12 as contained in the state's motion?
Guilty.
Are those counts true or not true?
True.
Okay. And are you telling me that each one of those counts are true because what they say in those counts about you is true?
That's true.
It's true. I'm saying you're not telling me that those are true just so you can get a certain plea agreement, right? Everything that's alleged is true. Okay. Court will accept Mr. Egret's pleas are true to each count as alleged. Any objection to the state's evidence, Mr. Stevens?
No objection.
State's evidence is admitted. The court takes judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor.
From the defense?
No, sir.
All right, Mr. Egret, based on your plea of true to each count as alleged, the court finds that you have violated the terms and conditions of your community supervision. Court hereby adjudicates your guilt, convicts you of possession of controlled substance in penalty group 2, less than 1 gram. That should be greater than or equal to 1 gram, but less than 4 grams, correct?
Yes.
So we'll need to change this judgment. Because the judgment says state jail. I mean, it says 3rd degree, but it says POCS PG2 less than 1 gram. So it needs to be POCS PG2 1 to 4. So the court convicts Mr. Egret of possession of controlled substance penalty group 2, greater than or equal to 1 gram, less than 4 grams, a third-degree felony. The court assesses his punishment, adjudicates his guilt, revokes his community supervision, assesses his punishment at 2 years confinement in the Texas Department of Criminal Justice Institutional Division, orders him to pay the balance of his financial obligations, and awards him 46 days credit towards his sentence for the time that he has spent in jail on this cause. So if we can just get that first page changed, then I've already signed this, the rest of it. So Mr. Eger, you're hereby remanded to the custody of the Van Zandt County, to the custody of the Van Zandt County Sheriff so we can carry out the terms and conditions of the sentence. I'm gonna have you step forward to be fingerprinted. Yes, thank you, Mr. Stevens. Mr. Sanders, you ready on Justin Harrell? You may.
Motions to dismiss, both, they're not on your docket. Both these gentlemen, ladies and gentlemen, I'm not sure, they're both deceased. We previously withdrawn the warrants on them. We just never dismissed the cases. The clerk's office brought these to my attention. So we're just basically cleaning up the docket for the year. We've already received enough confirmation that they are in fact deceased. So we're going to continue to hold cases against them.
All right, this is cause number CR 21-263, State versus Justin Wayne Harrell, set for status on the CPS records review. The court has conducted its in-camera review of the CPS records. At this time, the court has not found, I'm sorry, Mr. Harrell. I thought you were already up here. I apologize, sir.
You're okay, Your Honor.
All right, this is set for the CPS records review. The court has conducted its in-camera review of the records produced to it. The court had requested some instructions on how to review the records with regards to time and allegations. At this time, the court has not found any records that it believes to be mitigating or exculpatory. However, I'm not ready to issue my order on that just yet. So I'm gonna go ahead and set it for docket call, but I do want to make one more cursory review of one set of records. My initial inclination was not mitigating or exculpatory, but I do want to make one more cursory review of it in the sense of giving the most deference to exculpatory or mitigating for the defense use. So that shouldn't take me very long, but I'm going to go ahead and set it for docket call, and then I will have an order issued between this time and that time. Okay.
And Judge, I think probably the court is clear. The issues we were looking at, I was just giving some information from family that the basically the person who was the outcry witness in this case had made other claims against the mother of the alleged victim, and so that we felt like be an issue. So that was basically the CPS records.
Okay. And so were there any other pretrial issues that we were needing to discuss other than that?
Judge, I think we'd also, or at least I asked about having a hearing just on this bond situation, asking for the court to grant a PR bond. As I filed a motion now, I was going to ask if we could just address that briefly.
Any objection from the state on taking that up at this time?
State didn't have any notice that we were doing that today.
Judge, I think that was what was said back in February. That was my understanding. That's what we had said back in February. Because I filed the motion back then, but then it got reset. So that was what I was thinking. Actually, that's what I was thinking. The hearing was about more of that than the CPS records. Maybe you That was the case. That was my understanding.
When did you think that was originally set?
In February 24th. And I think that was the date that there was bad weather and so
Oh,
everything
yeah.
got canceled that day.
Motion to reduce bond, yeah.
Honestly, it's just a brief request I have for a PR bond.
It's a request for a bond reduction or a PR bond?
Well, bond reduction, and after talking to my client, I think I filed that February 10th, and after talking to my client more and his wife, really would be asking for a PR bond because I think my understanding, talking with any lowering any amount really doesn't make much difference as far as their ability to pay enough bond amount.
I do show in the file, in the record, that Mr. Harrell did have a personal bond in this case. And that he violated the conditions of pretrial release by testing positive for methamphetamine. I will allow you to have a hearing, but I'm going to tell you it's going to be a very difficult obstacle to overcome because we did grant him a personal bond previously, and he violated that by testing positive. So, hopefully he's not testing positive now, but it's going to be a difficult hurdle to jump over. But I'm fine with giving you a hearing today. Do you want to call him?
Judge, no, actually, I was just going to make a brief argument to the court.
Yeah, go ahead.
Judge, and he knows that because of what happened previously, I know there were issues with the GPS monitor and the dirty drug test. And just talking with him, I know he apologizes for that. He knows he messed up, especially with the meth use. Judge, I think that was back in October when we came to court. His bond was declared insufficient and raised. We would just be asking for another opportunity. That's his request, to have another chance to be out on a PR bond with the GPS monitor. He's indicated he's willing to go to NA classes or NA meetings or any other kind of classes regarding substance abuse the court would deem appropriate. He's in a position with family to be able to make the initial payment to get the GPS monitor installed, and then to go ahead and start working. And so for those reasons, Judge, we'd ask for another opportunity to be out on the PR.
All right, court's going to deny your request. And I'm also going to correct the record. It appears that I've already finalized my review of the CPS records. I've lost my memory on that, but yeah, it appears I've signed that order it was filed of record February 16th, and that there was a portion of a CAC video that I believed should have been produced to the defendant. So if you don't have a copy of that order, we can get you a copy, or the state can get you a copy, put that in discovery, perhaps. All right, if there's no other pretrial issues, then the court is going to set Mr. Harrell then for a docket call. You available either May 12th or 14th, I'm sorry, May 10th or 12th?
Yes, May 12th, we can do that. I think
May 12th.
Person set that day, so that'd be great.
All right, court will set Mr. Harrell for docket call May 12th at 1:30 if he remains in jail, 9 a.m. if he's in jail. Donald Ellis, CR 19305. Do you want Mr. Ellis at council table or is he fine where he's at?
Yeah, I think it's fine.
Okay.
That works.
All right, this is cause number CR 19305. This is set for evidence on the defendant's motion to dismiss indictment. Go ahead, Mr. Sanders.
Thank you, Judge. And Judge, basically have an argument concerning the indictment issue. I realize I think I'm the fourth attorney on this. I know Ms. Beasley had previously filed a motion to quash last year. And my understanding was at that time, I believe prior to the court's ruling on that, the state had done a second amended indictment presented to the grand jury. My understanding it did a second amended indictment. It's our position after reviewing that and kind of looking at the history here. I think there were the initial indictment was in December 2019, and then there was an amended one February 2020, and then a second amended indictment in July of 2021. And Judge, at least in looking at go to the code of procedure 28, 10, and 11, for an indictment to be amended, there has to be a motion filed and a court ruling, and then the amendment to the indictment, the interlineation, either physically on the actual indictment or an attached amended language. And it's my understanding with this situation that rather than doing it that way, there was no opportunity for the defendant to object. Even 2811 talks about all amendments of an indictment or information shall be made with leave of the court and under its direction. And I don't think that happened in this situation. I think it was just presented again to the grand jury, different grand jury. But it's still under the same cause number. And so that there's, I guess, some confusion on my part. That's why we look forward to filing this motion to dismiss. We don't think it was done in the proper way in making these amendments to the indictment.
State.
Thank you, Judge. I'd like to call myself to testify on this issue. Very briefly, Judge.
We're just making an argument. Do you want to, does it need to be testimony?
Judge, if there's no testimony, I'll be arguing outside the record, but I have made Mr. Sanders aware of these facts already. He is aware of the procedure and process that was used here. So maybe if we proceed, then if he wants testimony on the record, I'll be happy to do that.
Let's do that.
Your Honor, Mr. Sanders is correct. The 2811 addresses amendments to indictment, but it addresses non-substantive. When there is a change of the charge, when there is wording that makes the charge go from invalid to valid, or from one offense to another offense, not merely a method of committing an offense, it is not an amendment that a court can authorize. A court can only authorize because a defendant has the right to have his case presented to the grand jury. A court can only authorize non-substantive, substantive to the essence of the charge, amendments to the indictment. In this particular case, Judge, what we did on both of the occasions that have been pointed out by Mr. Sanders is we took the case back to the grand jury and re-presented the whole case to the grand jury. A second time that resulted in an amended indictment, and a third time that resulted in a second amended indictment. And perhaps, Judge, the confusion is the use of the word amended in the title. Perhaps it would have been much clearer if it had been labeled superseding indictment or second superseding indictment. I did find some case law with some cases where that had been done. The procedure that was used here, Your Honor, by taking the whole case back to the grand jury, doing a full grand jury presentation of the facts, having the grand jury pass on the probable cause for the new wording in the indictment, ensured that all of the defendant's rights were protected. It also ensured, Your Honor, that the defendant maintains all jail credit that he has earned up until this point. For example, we certainly had the option at any point of dismissing our case and re-indicting. That would have resulted in a different cause number, a different TRN number, all of which very well could have resulted in TDC not affording, should Mr. Ellis be convicted of this offense, as we believe he will, TDC not affording him the pretrial detention credit for the quote other indictment, or the indictment that was ultimately dismissed. Additionally, Judge, doing it that way would skew a lot of different statistics, violent crime statistics that we're required to report, that a lot of different organizations and agencies have to track, because it would look like we had double sexual assaults here instead of just one sexual assault. So for those reasons, the decision was made to protect Mr. Ellis's rights, to have his case fully presented to a grand jury, to ensure that he got all of the back time credit he would be worthy of should he be convicted, and to make sure that the statistics were done correctly. We elected to move forward with this process. Judge, as this court knows, everything that appears on the face of a physical piece of paper labeled indictment, everything that appears on it above in the name and by the authority of the state of Texas is surplusage, is not necessary. So those words, Second Amendment and indictment, in essence, are not necessary to the validity of the charge itself. On the face of this document that's labeled as an indictment, beginning with in the name and by the authority, ending with against the peace and dignity of the state, signed in the foreperson of the grand jury, along with the clerk's file mark at the top. It is a valid indictment presented in all respects to a Van Zandt County grand jury, and there is no evidence to the contrary. It will be the defendant's burden to show that it was not validly presented to a grand jury. And that cannot be done here because it was presented in a manner and method that would ensure that Mr. Ellis's rights were protected.
Mr. Sanders, do you want to respond?
No, Your Honor, other than just that, at least in talking with my client and looking at what had been done previously in the case of Dr. Springfield, been busy about it. We were urging this motion is based on 281011 regarding how indictments are to be amended. So that's our position.
Right, so it appears that the very first indictment in this case, which carries the cause number CR 19305, was returned by the July term 2019 grand jury of Van Zandt County. Is that correct?
I believe so.
That was filed December 18th of 19.
Yes, that's right.
And then there was a subsequent indictment, same cause number. CR 19305, aggravated sexual assault of a disabled person. That was returned by the grand jury of record February 28th, 2020, returned by the January term 2020 grand jury. Is that correct?
Yes, Your Honor.
And then what appears to be the most recent indictment carrying the same cause number CR 19-305 is entitled Second Amended Indictment and appears to be returned by the July term 2021 grand jury filed of record July 23rd, 2021. That includes 2 enhancement paragraphs. Is that correct?
Yes, sir.
So Ms. Curry, you're telling the court that each one of these indictments was not the result of a hearing before the court requesting a non-substantive change or amendment to the indictment, but was a representation of the entire case to the Van Zandt County grand jury, wherein each one of these indictments, although carrying the same numbers, would supersede the one before it.
Exactly.
So the court will take judicial notice of all of the indictments on file in this cause based on the plain language contained in each of the indictments. The court would find that each indictment has been returned by the Van Zandt County grand jury and constitutes superseding indictments rather than amended indictments, and that the Van Zandt County grand jury would be the proper body to issue any indictment based on a requested change of substantive change that could either increase or decrease the charge or provide additional charges to which the defendant would have to defend. So the court will find that the indictments have not been amended by judicial process by the court rendering an opinion and determination, a judicial determination, but that each indictment has been rendered by the Van Zandt County grand jury and constitutes a superseding indictment in each case. So on the basis of the court's review of the file, court taking judicial notice of that, the arguments presented today, the court will dismiss and deny the motion to dismiss the indictment. Thank you, Judge. So are we set on Mr. Ellis?
I don't think so. If we can have the May 12th docket call date. that would work.
All right, court will set Mr. Ellis for docket call on May 12th at 1:30.
John, while we're, I'd like to make a plea on the record, so Mr. Ellis knows exactly what it is. There's plenty of time from now till May 12th to consider the offer. Your Honor, the state's final plea offer in this case is 35 years in the penitentiary.
All right, court will see Mr. Ellis on May 12th for docket call. Is that all you have, Mr. Sanders?
Yes, Your Honor.
Thank you, sir. Yes, sir. Mr. Ashmore, are you ready? Who are you ready on? I'm ready to get ready to you. Keith, you may.
We've got Mr. Butler and Miss Vasquez who are ready to plead, and then we have some other matters.
Ms. Vasquez, you'll come forward. Sorry, Mr. Butler. All right, Ms. Vasquez, if you will, raise your right hand. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay, gotta speak up so my court reporter can write it down, okay? All right, you may put your hand down. You are Liliana Vasquez, is that right?
Yes, sir.
And Ms. Vasquez, in this case, you're represented by your attorney, Mr. Ashmore. Are you pleased with his representation of you?
Yes.
You feel like you've had enough time to discuss your case with him?
Yes,
Have all
sir.
of your questions answered?
Yes, sir.
Is there anything about this paperwork that you've read and signed today that you do not understand? You understand everything you've
Yes.
read and signed? And Mr. Ashmore, do you believe Ms. Vasquez to be competent today?
I do, Your Honor.
I see that Ms. Vasquez is currently on community supervision. She got there because on December 18th, 2018, she appeared before the court. She pled guilty to injury of a child, elderly, or disabled individual with reckless bodily injury. Court reviewed the evidence, found there was enough evidence to convict her. The court, however, deferred a finding of guilt, placed her on community supervision for 3 years, and assessed a $1,000 fine. The state subsequently, during that term, filed a motion to adjudicate and revoke, and filed in that motion filed 5 separate counts. Mr. Ashmore, is it your client's intention to plead true to all counts and waive the reading of the motion?
That's correct, Your Honor.
All right, Ms. Vasquez, at this time, I want to ask you, how do you plead to counts 1 through 5 as contained in the motion? Are those counts true or not true?
True.
And are you telling me that those things are true because what's alleged is true? You have to say yes or no.
Yes.
Shake your mind down. Yes. And has anyone threatened, forced, or pressured you to make you feel like you had to plead true?
No.
All right, the court will accept the defendant's pleas of true to each count as alleged. Mr. Ashmore, any objection to the state's evidence?
No, Your Honor.
All right, state's evidence is admitted. The court takes judicial notice of Ms. Vasquez's judicial confession. Anything further from the state? All right, anything further from the defense?
No, thank you, Your Honor.
All right, based on Ms. Vasquez's pleas of true, the court will find that she has violated the terms and conditions of her community supervision. The court will follow the plea agreement she's reached with the state. The court hereby adjudicates her guilt, convicts her of injury to a child, elderly, or disabled individual by reckless bodily injury. The court revokes her community supervision, assesses her punishment as 7 months confinement in the state jail division of TDC, orders her to pay the balance of her financial obligations, orders and awards her 65 days credit towards her sentence for the time that she has spent in jail on this cause. I'm gonna have you step forward to be fingerprinted, Ms. Vasquez, and Mr. Ashmore, I'll need you to sign here in the plea agreement as well. I'm missing one spot. Let her fingerprint. Yes. All right, Mr. Butler. Just watch your step when you go through there, okay? All right, this is CR 15-9, State versus Christopher Stephen Butler. Mr. Butler, if you'll raise your hand, sir. Mr. Butler, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God? Yes, sir. All right, you may put your hand down. Mr. Butler, you're here on a motion to adjudicate your guilt, and you're represented by your attorney, Mr. Ashmore. Are you pleased with his representation of you?
Yes, sir.
Do you feel like you've had enough time to discuss your case with him
Yes, sir.
and have all of your questions answered? You gotta let me finish the question. Otherwise, you don't know what you're saying yes, sir, to. I know you've heard it, you know what I'm gonna say, but it's important that it's on the record. All right, so you're pleased with him?
Yes, sir.
Feel like you've had enough time to discuss your case with him, get all your answers to all your legal questions?
Yes, sir.
Anything about the paperwork that you've read, signed that you do not understand?
No, sir.
Mr. Ashmore, do you believe Mr. Butler to be competent today?
Yes, sir, I do.
And you've explained to him his legal rights as they pertain to this case?
Yes, Judge.
All right, I see here that Mr. Butler's going to plead true to all counts as contained in the state's motion to revoke his community supervision. And the state's going to be recommending that he be adjudicated, that he be revoked and that he receive 12 years confinement in TDC with a balance of his financial obligations and receiving 197 days credit towards his sentence. Is that both of your gentlemen's understanding?
Yes, sir.
All right, so Mr. Butler, you did appear before the court on March 6th of 2015. You pled guilty to possession of controlled substance, penalty group 1, 4 grams to 200 grams, a second-degree felony. The court heard the evidence in the case. The court approved your plea agreement, placed you on deferred community supervision for 7 years. And it's been during your community supervision that the state filed its motion to adjudicate and revoke. And they have alleged in 7 separate counts ways that you have violated. You've reviewed that with your attorney, correct?
Yes.
So at this time, Mr. Butler, I'm going to ask you, do you plead true or not true to those counts as they're alleged?
True.
And are you pleading true to each one of those counts because what they're alleging is true?
Yes.
Has anyone threatened, forced, or made you feel like you had to plead true to any count?
No, sir.
Court will accept the defendant's plea of true. Mr. Ashmore, any objection? State's evidence?
No, Your Honor, thank you.
State's evidence is admitted, and court does take judicial notice of Mr. Butler's judicial confession. Anything further from the state? From the defense?
No,
All right, based on the defendant's plea of true to the motion, court finds that Mr. Butler has violated the terms and conditions of his community supervision. Court will follow the plea agreement. Court adjudicates his guilt, convicts him of possession of controlled substance, penalty group 1, greater than or equal to 4 grams, less than 200 grams. Revokes his community supervision, assesses his punishment at 12 years confinement in TDC. Court orders him to pay the balance of his financial obligations and awards him 197 days credit towards the sentence for the time that he has spent in jail on this cause. Mr. Butler, I'll have you come forward to be fingerprinted. Mr. Ashmore, I'll have you come forward to sign the paperwork.
yes.
Or are you ready on Ms. Stokes or Ms. Thomas?
Judge, we're ready on Ms. Stokes.
Ms. Stokes, if you'll come forward, please. CR 2018.
Yes, Judge, we thought we had an agreement with the state or an alternative agreement, which would be a situation where we go open. My client has been extended an offer either way that includes safe P. So adjudicate guilt, safe P, straight probation, or alternatively make that pitch to the court to stay on deferred, go to safe P, stay on probation. She's rejected those offers and has asked for a jail offer, a TDC J offer. And something that Ms. Heisel brought to our attention is we still haven't fixed the getting both cases combined. I thought that there was some sort of conflict. Anyway, whatever. I need a moment to straighten that out, and we need a prison offer from the state of Texas. So we're asking the court, unfortunately, to reset this. It could be a very quick reset, so we could just get the cases, the misdemeanor transferred up. They all arise out of the same criminal episode, and that way we can get an offer from the state, take care of both matters, and conclude for business here in Bailey County.
I'm pretty sure we've already done.
No, we didn't get it right, Judge. We messed it up. We filed it up, and then we thought it was rejected because there was a conflict up here. Then we filed it down, and that was rejected. So there's been a lot of brain damage, and I apologize. I thought we had it figured out before this hearing, but we didn't get it done.
I show that on a week ago that I accepted it and it's in this court. Cause number 2020-94. Judge Winters signed it on May 24th. I'm sorry, March 24th. I signed it March 24th. It's here.
Okay, well, I was under the impression it had been rejected again, so,
No, it's in the clerk's file.
okay.
Now it's showing to be in the county clerk's file. I don't know if it's in the district clerk's file, but it's in the.
Yeah, Judge, the only notice I got was a notification from e-filing that I guess maybe it was the district court one had been rejected. So I assumed that it had not been transferred, but maybe there was just a duplicate going on.
So either way, you're saying that y'all have a plea agreement worked out on time?
Your Honor, I've not made an offer for time yet, because up to this point, she was asking for safety. I would be able to make an offer. We obviously can't have done today because we weren't anticipating this change in direction. But I do believe that if we reset it I don't think it's necessary to set it all the way to the next contested docket. From what I understand, if she does not want to accept my TDC offer, we'll be going open, so a full contested hearing won't be necessary. It will just be argument on punishment, basically. So I think it can be set before the next contested docket either way.
We might as well just set it for the next contested, because right before that's going to be the 26th. April 14th is pretty full. So we'll set it for April 28th, and that'll be the final time. That'll be the final hearing. Either she's got a deal or just argue the motion. But if you'll check the clerk's file, the county clerk's file, I show that
It's been.
Is that likely why the district court rejected the county clerk had already put theirs on trial?
I don't know, but I thought there was a conflict because of the age of the case. What happened? So.
Rebecca Thomas, CR 18-452. All right, this hearing on Ms. Thomas's motion to revoke.
Judge, we're here. We have a 9-month TDCJ offer that the client has refused, so we just need to proceed.
Unfortunately, we're at 5 o'clock, so. I think we're just going to have to reset her until April 28th and take her up at 1:30. All right, Ms. Thomas, I'm gonna reset you until April 28th. Then we're gonna do your hearing that day. It's 5 o'clock, and we were gonna have a hearing. We'd have to start it a lot earlier. I wasn't aware that we were gonna have a contested hearing in your case, or I would have called you earlier and we would have done it. Okay. So Mr. Ashmore is gonna have you sign this notice of appearance, and then if y'all work something out before then, let me know, and we'll try to work you in. Otherwise, we'll be back on the 28th.
Thank you, Judge.
I don't believe we have any names to call from earlier today. Let's see. Yeah, he's gonna fill out a form here. Hey, have you signed it? It'll have your new date on it, okay? All right, I believe that will conclude the business of the court today, and so we'll be